asked you who could have given Jason Johnson the pills that killed him. Well, Your Honor, as soon as the prosecution asks you a question, you know that they have not come even close to meeting their burden. Because in this court of law, questions aren't enough. Maybe isn't enough. Likely isn't enough. More than likely isn't even enough to prove my client's guilt. The prosecution has the burden of proving my client's guilt beyond a reasonable doubt. But today, they have given us nothing but reason after reason after reason to doubt her guilt. Find Ray Concha not guilty. Thank you.
On behalf of the people of the state of California. In this afternoon's trial, we conducted the direct examinations of Alex Weaver and Principal Riley McAllister, as well as the cross-examination of Avery Perkins. I'll also be delivering the closing argument.
Good afternoon, Your Honor. My name is Gabriel Grossman. In today's trial, I'll be conducting the direct examinations of Officer Doherty and Dr. Sanchez, as well as the cross-examination of Dr. Burke. At this time, our witnesses please introduce themselves.
Yes.
Good afternoon, Your Honor. My name is Julia Nat, and in today's trial, I will be portraying Riley McAllister.
Good afternoon, Your Honor. My name is Liam Howell, and in today's trial, I will be portraying Alex Weaver.
Good afternoon, Your Honor. My name is Anne Basu, and in this afternoon's trial, I will be portraying Officer Robin Doherty.
Good afternoon, Your Honor. My name is Justin Gels, and in today's trial, I will be portraying Dr. Ricky Sanchez. May our court clerk please introduce himself.
Please.
Good afternoon, Your Honor. My name is Eric Sheep, and in today's trial, I will be your courtroom clerk. I will be giving time signals of 2 minutes, 1 minute, 30 seconds, and time. May our attorney coach please introduce herself?
Yes.
Renee Korn, Betty Minislew over in the corner.
All right, thank you. Thank you very much. All right. Go ahead.
Good afternoon, Your Honor. My name is Annie Choi, and I represent the people of the state of California. The people respectfully request you deny the defense motion and permit the admission of the incriminating item in the defendant Ray Concha's car as seen in plain view by Officer Doherty.
Let me stop. Your opposition counsel made the argument just now about the fact that in this case, Officer Doherty did some gymnastics, essentially, to try to see inside his car. Stood on the wheel well, leaned over, got his flashlight in there. Is that reasonable? Is that a reason? I mean, if he's got to do that, shouldn't he have to go get a warrant to do that? I mean, to search the car, go to a neutral magistrate like a judge like me and get a warrant for probable cause instead of just taking it on his own initiative and start leaning over cars, leaning over the hood of the car and doing gymnastics, look inside.
Well, Your Honor, in the court case Texas v. Brown, the court ruled that bending down was irrelevant to the Fourth Amendment analysis. Okay. Now, similar to bending down, if you step up, those two positions aid in allowing the officer to get a clear view of the interior of the car. So, the difference between bending down and stepping up is essentially gone, because stepping on the hood of a car is the equivalent as bending down.
Keep going.
A roll of money, an accounting list, and a bag of orange-colored pills. Those items were in plain view in the defendant's car when they were observed by Officer Doherty on the night of Friday, February 22nd. Because those items were in plain view, there was no violation of the defendant's Fourth Amendment rights. The defense argued that Officer Doherty violated the defendant's Fourth Amendment rights by looking into the interior of the car. But in the U.S. Supreme Court case, U.S. v. Copland, the windows of an airplane were clearly open to the public, showing the interior of the airplane along with illegal marijuana.
But in Copland, the officer, as I understand, simply used the flashlight, looks right into the plane, and saw something incriminating right away. Here, the officer shined the flashlight, and all he sees at first is simply, I think, the backpack, nothing really incriminating at all. I mean, he sees, all you can see, I think, is a sweatshirt draped over the back. Correct me if I'm wrong, but a sweatshirt draped over the backpack. That's what he sees at first. That's all he sees. really nothing incriminating. I understand in Copland, right away, you see something incriminating shining that flashlight. So isn't there a difference here?
Your Honor, the officer had reasonable probable cause to believe that the defendant had incriminating items located in the interior of the car.
How did he have probable cause okay, so your probable cause doesn't mean go get a warrant then? I mean, here he's operating, I think you're suggesting a plain view doctrine. You're right, probable cause, if he goes and gets a warrant and tells the magistrate, there's probable cause, I should be able to search this car, he takes it on his own volition. He's not the one to determine that. He can only really do it if there's an exception to the Fourth Amendment. What's the exception? What's the exception that you're allowing, that you want to say that Officer Doherty, that evidence should come in?
Your Honor, well, in a car there is a lowered expectation of privacy, and society views that as reasonable because of the glass windows that a car has.
Didn't he tint his windows? Weren't those windows tinted? Wasn't he driving it at night? Didn't he, I understand, he purposely draped the sweatshirt over the items.
Your Honor, the tinted windows only provides a tint. It is not a barrier. You can still see through to the interior of the car.
Okay, go ahead.
Now, in the U.S. versus Copland court case, it was determined that the airplane windows showed the interior of the car. Now, similar to a car, an airplane is a mode of transportation with windows from which one can see to drive. The items placed inside these different modes of transportation are open to anybody who can see the interior of the vehicle. In Katz versus U.S., it was determined that there are two essential questions that determine whether or not the Fourth Amendment was violated. First, has the person shown an actual expectation of privacy?
Right, okay, let's talk about that for a minute. That's Justice Harlan's concurring opinion, correct? He talks about that, he sets up this two-part test. So again, has the person shown a subjective expectation of privacy if he's taken efforts to drive his car only at night, to drive it to a town where he didn't want to be found out necessarily, where he didn't want to be away from others? There's a reason he does this, as I understand. Ray, it's a he or she, I apologize. And he drapes the jacket over the back of his items. So isn't there a reasonable expectation of privacy that the court should respect in this case?
Your Honor, I believe there was a lowered expectation of privacy because the defendant's car was parked in a public parking lot in a local supermarket with a partially opened window. Those are indicators of the lowered expectation of privacy.
Okay, but then you go to Horton, and Horton's got this three-part test, Horton versus California, about plain view. The officer has to lawfully be present, he must have lawful right of access, and the incriminating character has to be immediately apparent. Do we have that third prong here? Was the incriminating character immediately apparent? I mean, when he shines that flashlight in the first time, is there anything incriminating?
Your Honor, I believe that it was one continuous search from the side passenger to the front windshield of the car because both windows allow for clear view of the interior of the car. And when
Is that a lawful right of access to start standing on passenger tire, the passenger side tire well, and lean yourself over? Is that a lawful right? I get it. If he walks up to the car and shines a flashlight in, that's one thing, perhaps. But here he did something more.
Your Honor, but the officer was not using a technical device. It was simply a flashlight to look into the interior of the car.
Go ahead.
And second, does society view this expectation as reasonable? Now, because of the glass windows that a car has, the car by nature has a lowered expectation of privacy. The windows allow any passerby to look into the interior of the car from outside. So even though Officer Doherty was on the hood of the car, she would have been able to see the exact same things that she saw if she was standing in front of the car, on a curb adjacent to the car, or if she had an aerial view. The defense argued that Officer Doherty was not in a legal public space when she looked into the front windshield of the car.
The
California case People v. Rogers, the court ruled that the use of flashlight does not define a search.
In Rogers, though, didn't the defendant, as I understand it, the defendant there opened the door to the van for the police. And the police then had their opportunity to shine the flashlight right in. It was almost like they were just, come right in, folks, open the door to the van. You didn't have that here. Did you? This car is locked in a parking lot. He's not there to open the doors for anybody. Is that distinguishable, counsel?
Your Honor, but it is not necessary to have a defendant present in the car because a car is different. A car has a lowered expectation of privacy with the clear windows and the big 360-degree.
But in Rogers, it was night. The Vance interior was dark. It was difficult to see. But there, because the defendant opened the door, he shined his flashlight in. Here, there's no defendant to open the door, right? He shines the flashlight in. He doesn't see anything at all. Doesn't it stop right there? Doesn't he have to, at that point, if he thinks something's going on, have to go get a warrant at that point?
No, Your Honor, because what the officer saw in the front windshield of the car still is the same as what he would have seen from the side of the car because they are all in plain view. From what he saw in the front windshield of the car.
What does the front windshield mean when he leaned over the car and looked through the front? Is that what you're saying?
Yes, Your Honor. If we use a hypothetical, a tall officer would be able to see the exact same thing as this shorter officer who had to climb on the hood of the car.
Wait, you're telling me that if this officer had been taller, he wouldn't have had to lean over the car?
Yes, Your Honor.
Right. How do we know? Do you know how tall this officer is?
No, Your Honor.
So we don't know. This officer could have been Shaquille O'Neal size. I don't know. I mean, so.
Then it wouldn't have been necessary to climb over the hood
How
of
do
the
we
car.
know? How do we know? We don't know, do we? This officer could have been 7 feet tall.
Yes.
Do you know if he's 7 feet tall or 5'3"? Do you know?
No, Your Honor.
Okay. All right. So, I don't know. That's literally no moment to me. Go ahead.
The flashlight only aids in vision and detecting incriminating evidence that is already in plain view. Similarly, from where Officer Doherty was standing, the flashlight only helped in allowing the officer recognize the dangerous items in the defendant's car. The court should admit Officer Doherty's testimony as to what she witnessed in the interior of the car. In a moving vehicle, especially with our court case today, there is a lowered expectation of privacy because of a simple fact. The glass windows surrounding the car leave the inside of the car open to the public. Your Honor, Ray Concha did not have a
But they were tinted windows.
Yes, but one of the windows
Go ahead.
were partially open.
Yeah, but he wasn't looking through that window, was he? When he found the incriminating, what you seek to admit in this case, wasn't found when he was looking through that cracked window. It was when he was leaning over and looking through the tinted center window, the front windshield. Isn't that correct?
Yes, Your Honor.
All right. Anything else?
Yes. Your Honor, Ray Concha did not have a reasonable expectation of privacy because the defendant's car was in a public parking lot with a partially open window. Thank you.
Okay, thank you. Rebuttal?